Welcome to the CE.way presentation about the EU Cosmetics notification. The EU Cosmetics Regulation says that prior to placing the cosmetic product on the market, the responsible person shall submit by electronic means the following information to the Commission. Therefore, we can conclude that notification is a pre-market requirement, meaning that it has to be performed before the products can be placed on the market, and it has to be performed by the responsible person. Contact CE.way to find out which information needs to be notified to the Commission. Please remember that the notification can be performed only after the cosmetic products are compliant with the regulation and any other applicable legislation, which might be the case, for example, for cosmetic products packaged in aerosol dispensers. Notification is a final step before the products can be placed on the EU market. Having performed the notification, however, doesn't mean that your obligations are finished. Also, after the notification has been performed, you must keep your products compliant with the regulation and inform the responsible person of any changes made to the product or the product information file. Note that certain countries might impose additional laws, which you have to fulfill to be able to sell in those countries. Such laws might relate to customs clearance or taxes to be paid, etc. What is a notification? Notification is not the same as registration, as notification is a one-sided action from the responsible person to the authorities, and therefore doesn't imply any official approval for sales. Registration, on the other hand, is a two-sided action. In the case of a registration, the authorities would provide a reply and an approval. The notification process for cosmetic products is changing along with the change in the applicable law for cosmetic products in the EU. Notification under the Directive 76/768/EEC had to be performed to the competent authorities and anti-toxic centres of all the countries where companies wanted to sell their products individually, and many countries had different rules and requirements regarding the notification. Under the Regulation 1223/2009, though, simplification has been achieved. Notification is now centralised and electronic, and has to be performed to the CPNP portal only once. The Regulation 1223/2009 becomes fully applicable on the 11th of July 2013. The CPNP portal started functioning already before that, on the 11th of January 2012. Notification to this portal is, however, mandatory only from the 11th of July 2013. Be aware that all the products currently on the market will have to be re-notified to the CPNP portal, also those which have been already notified to individual countries under the Directive 76/768/EEC. Additional notifications might have to be performed in some cases. If a distributor puts a cosmetic product on the market in a new member state, while this product is already sold in other member states, and translates its labelling to comply to the local national law, he has to resubmit the following information to the Commission: the category of the cosmetic product, its name in the member state of dispatch, and its name in the member state in which it is made available, the member state in which the cosmetic product is made available, his name and address, the name and address of the responsible person for this product. Distributors should also notify or inform the responsible person if they reintroduce the product to the market, as well as informing the RP of certain products if they discontinue with the distribution of these cosmetic products. The reason for this is that the responsible person should always have an updated list of distributors for products for which he acts as a responsible person. The second case where an additional notification should be performed is if a product contains certain nanomaterials. The responsible person shall notify them to the Commission by electronic means 6 months prior to being placed on the market, except if they have already been placed on the market before the 11th of January 2013 by the same responsible person. In that case, cosmetic products containing nanomaterials shall be notified to the Commission between the 11th of January 2013 and the 11th of July 2013, in addition to the regular notification. This does not apply for cosmetic products containing nanomaterials that are in conformity with the requirements set out in Annex 3 and nanomaterials used as colorants, UV filters, or preservatives regulated under Article 14 and Annexes 4 to 6 of the regulation unless explicitly specified. In the event that the Commission has concerns regarding the safety of a nanomaterial, the Commission shall request the SCCS to give its opinion on the safety of such nanomaterial. The regulation lays down the minimum information to be notified to the Commission for the notification of nanomaterials. Contact us if you would like to know what this information is. The responsible person may also designate another legal or natural person by written mandate for the notification of nanomaterials and shall inform the Commission thereof. We hope you found our presentation useful. More information about the notification of cosmetic products in the EU can be found on our website. You can also contact us via email or through social media channels to find out more.